Dr. Mahmoud qualified as a doctor in 2015 from Suez Canal University in Egypt. He then moved to the United Kingdom and obtained full registration with the General Medical Council and a license to practice in 2018. At the time of the events leading to this case, Dr. Mahmoud was working as a Foundation Year 2 doctor at West Suffolk NHS Foundation Trust. Prior to this, he had been employed as a Foundation Year 1 trainee at Suez Canal Teaching Hospital between March 2016 and February 2017. The allegation against Dr. Mahmoud relates to his conduct on Facebook, where he posted numerous offensive and/or racist comments and images between the 18th of July 2015 and the 22nd of July 2018. These posts were publicly available for anyone to view on the internet. The GMC received a complaint via email on the 13th of October 2018, which raised concerns about the content of Dr. Mahmoud's Facebook posts. The tribunal considered various pieces of documentary evidence presented by both parties in the case. The evidence included, but was not limited to, an email from the complainant to the GMC dated the 13th of October 2018, another email from the complainant to the GMC with 3 examples of Dr. Mahmoud's Facebook posts dated the 20th of October 2018. An email from Dr. Mahmoud to the GMC enclosing an earlier email to the GMC dated the 30th of November 2018, a preliminary report and related correspondence from the trust dated October 2018, a local investigation report of the trust dated the 16th of January 2019. An email from the trust to the GMC with the 37 Facebook posts captured during the investigation, and a letter from Dr. Mahmoud to the GMC dated the 27th of May 2019. The defense also provided a document bundle, which included Dr. Mahmoud's CV, an appraisal form, cost certificates, testimonials, and a personal reflection document from Dr. Mahmoud. All of this evidence was taken into account by the tribunal when considering the case. At the outset, the doctor, through his counsel, admitted all the allegations. The doctor also gave evidence during the hearing. The counsel, on behalf of the GMC, argued that Dr. Mahmoud's fitness to practice is impaired due to his offensive and graphic Facebook posts, which were publicly visible over a 3-year period. He stated that doctors are expected to be non-discriminatory and respect others, and that Dr. Mahmoud's actions fell below the expected standard. He referred to GMC guidance on social media and the relevant precedent to support his argument. Although Dr. Mahmoud has expressed remorse and made efforts to better understand issues related to discrimination, the counsel argued that a finding of impaired fitness to practice is necessary to maintain public confidence in the profession and uphold proper professional standards. The defense counsel presented arguments on behalf of Dr. Mahmoud in regards to his past misconduct on social media. He acknowledged that Dr. Mahmoud accepts the seriousness of his misconduct and has undertaken significant remedial work. He highlighted that Dr. Mahmoud has shown good insight and his fitness to practice is not currently impaired. The counsel suggested that a warning may be a sufficient response to meet the public interest, as it would sit on Dr. Mahmoud's registration for 2 years and not affect public confidence in the profession. He emphasized that Dr. Mahmoud has apologized, recognized the offensiveness of his past posts, and demonstrated his changed attitude towards professionalism. The defense also referred to the courses and behavior agreement that Dr. Mahmoud has completed, and the positive feedback from his mentor and supervisor. He concluded that not all cases need to lead to a finding of impairment and that a warning would uphold public confidence in the profession and still protect the public, while also sending a message to the doctor and the profession. The tribunal considered that the offensive material in question was posted on Facebook during a 3-year period while Dr. Mahmoud was training and working in Egypt, before he moved to the UK and gained full GMC registration. Dr. Mahmoud accepted that the material would not have been acceptable by his regulator in Egypt. The content of the posts was visible to the public and still available on his Facebook profile after he started working in the UK as a doctor. The tribunal concluded that the content of the posts was deplorable and contained discriminatory material against various ethnic groups, women, vulnerable children, and people with disabilities. As such, the misconduct, in this case, was deemed to be serious by the tribunal and would be regarded as such by any right-thinking medical practitioner or member of the public. The tribunal assessed whether Dr. Mahmoud's fitness to practice was currently impaired due to his serious misconduct. The tribunal acknowledged that serious misconduct of this kind is not easily remedied but noted that Dr. Mahmood had demonstrated some insight into his actions and had admitted to his misconduct at an early stage. He also had a mentor in place to assist him both clinically and personally, had undertaken equality, diversity and inclusion training, and there was no evidence of repetition since the incident. Positive accounts of Dr. Mahmood's professionalism, integrity, and commitment to patient care were also considered. Although the tribunal found that Dr. Mahmood had made progress in developing insight and remediating his misconduct, it considered the work incomplete and some of his responses naive in relation to discrimination that some groups in society can face. Therefore, the tribunal concluded that a finding of impairment was necessary due to the gravity of his misconduct, which had breached fundamental tenets of the profession, such as the duty not to discriminate against any member of the public based on their sex, race, religious beliefs, or disability. The tribunal found that a warning would not suffice to send a clear message to the profession that such behavior was unacceptable, and public confidence in the profession would be undermined if there were no finding of impairment. The tribunal, therefore, determined that Dr. Mahmood's fitness to practice was impaired by reason of his misconduct. The GMC argued that in order to maintain public confidence in the profession and uphold proper standards, a suspension order is appropriate and proportionate for the case at hand. The counsel referred to the sanctions guidance and noted the relevant mitigating and aggravating factors. He also argued that there are no exceptional circumstances that would justify the tribunal taking no action or imposing conditions, which would not be workable or proportionate given the severity of the case. He further cited the sanction guidance's paragraph that states suspension has a deterrent effect and may be appropriate for serious misconduct to protect the public and maintain confidence in the profession. The GMC suggested that a period of suspension would mark the serious nature of Dr. Mahmood's actions and have a deterrent effect, although the tribunal should consider the length of the suspension and Dr. Mahmood's visa status. On behalf of Dr. Mahmood, the counsel argued that conditions would be an appropriate and proportionate response to the tribunal's findings. He argued that erasure would be too harsh of a punishment for a doctor who is already working well under supervision. He also pointed out that Dr. Mahmood has reflected on his actions and has not exhibited any discrimination towards patients. The trust has continued to employ him and has implemented a behavioral agreement and courses to help him improve. The counsel suggested that imposing conditions on Dr. Mahmood would ensure he practices safely with guidance and feedback from the workplace, which would be a practical and effective way to maintain public confidence. He proposed a 6 or 12-month order for Dr. Mahmood to further study discrimination and gain a greater understanding of the harm his actions could have caused. The defense also argued that imposing conditions with a review would send a serious message to Dr. Mahmood, but if the tribunal deemed that conditions were not sufficient, a short period of suspension should be imposed. He suggested that the suspension period should not exceed 4 weeks as a longer suspension would disproportionately affect Dr. Mahmood's visa status. Nonetheless, a short suspension would still demonstrate the seriousness of Dr. Mahmood's actions and uphold public confidence in the profession. The tribunal considered both aggravating and mitigating factors in Dr. Mahmood's case. Aggravating factors included the offensive nature of the material posted, the length of time over which it was posted, the public availability of the posts, and the fact that the discrimination occurred in Dr. Mahmood's personal life. Mitigating factors included the fact that the posts were made early in his career and prior to his registration with the GMC, his previous good character, his admission of guilt and expression of remorse, positive feedback from colleagues and patients, and no evidence of repetition or discriminatory behavior towards colleagues and patients. The tribunal decided that taking no action would not be proportionate or in the public interest, and that imposing conditions on Dr. Mahmood's registration would not be sufficient to protect the public. Instead, the tribunal decided that a period of suspension was necessary to mark the seriousness of the misconduct, maintain public confidence in the profession, and maintain professional standards. A suspension of longer than 4 weeks would have a disproportionate effect on Dr. Mahmood's career, so the tribunal decided that a 4-week suspension was appropriate in light of the mitigating factors present. The tribunal did not direct a review of the case given the short duration of the suspension, Dr. Mahmood's progress, and the hospital's knowledge of the case.